Welcome to Vesta. You are at Vesta's New Hampshire Hub. The attorneys that will be speaking later are going to be talking about New Hampshire law. You'll learn some other things if you are in a different state, but the attorneys will specifically be talking about New Hampshire. Tonight's topic is legal and tax tips. So at Vesta, our mission is to provide education, connection, and support to help you navigate the divorce process. Vesta was started about 13 years ago by three founders who wanted a better experience. They themselves had gone through divorce and realized that there needed to be a better process, and that's where Vesta came about. So we have an experienced panel of professionals who are going to share their insights for preparing for divorce and understanding tax implications. And each panelist will give a little bit of description of what they do and how it pertains to taxes. So, with that, what I would like to do, we're going to start off with our financial piece. So, heavy on the tax topics. So, I'm going to introduce Barb first. Barb, go ahead and take it away.
Hi, good evening, everyone. I love talking about taxes. So, this is one of my favorite webinars that we have. What I wanted to talk to you about was really the taxes that you should consider when you're looking at a settlement agreement or thinking about a settlement agreement. What you'll find is the program is not just you take all the assets and you divide them in two, or you divide them by whatever percentage. You really need to take into consideration the taxes. There's nothing about getting divorced that is going to generate taxes. So if you start moving the houses, retirement assets, those those assets and that transfer is tax free. So there's no immediate transfer. However, when the assets move, the cost basis and the attributes associated with it, those also move. So you really need to think about what am I getting? Next slide, please. So I really want to focus on how you should review your settlement offer, or when you go into it, how you should really some things that you need to consider so that you're not all of a sudden blindsided with some tax consequences. So for example, if you're looking at a cash portfolio and you have a brokerage account, let's say one brokerage account you bought Microsoft stock and you bought it for $10,000, and that $10,000 worth of stock is now worth 500,000. You have a $490,000 embedded gain in that portfolio, and that you're going to have to pay anywhere from a 15 to 20% federal capital gains tax on it, plus any state taxes depending on where you live. So you could argue, so if you're looking at it, there might be an account that has this Microsoft in it, and maybe that's 500,000. And then you look at another account that has another account that may have 500,000, but you bought all the Microsoft yesterday. So that cost basis of that is 500,000. So those, even though on paper, those seem to be exactly the same, they're not, because one has an embedded cash option. So I just had a client where the husband offered to give her $100,000 of prepaid spousal support. That which should really, when you think about it, you're going to pay prepaid spousal support. That should come over in cash. He offered to give her an account that had not a $90,000 capital gain in it. So it really wasn't 100,000 in prepaid spousal support. It was really 100,000 less the capital gains tax. So it was more like 75, $80,000 that you were getting. So when you look at cash, you really should think about any embedded gains and tax consequences that might be within the account. Can we switch to the next slide, please? So when you Look at retirement accounts. I think the big thing here to remember is the retirement accounts are pre-tax dollars. So whenever immediately anything that you're going to be, when you look at this and it and you look at it and you think, all right, let's say the two biggest assets you have are equity in the home and retirement accounts. Those two things, they're just not equal because when you eventually take money out of that retirement account, you're going to have to pay taxes on, or have to pay taxes, and it's taxed as ordinary income. So again, it's something where, we'd love to have retirement assets. More often than not, couples, they have most of their marital assets are retirement assets. You just have to be really careful when you're given retirement assets. You want to make sure that what you're getting is really equal to what the other side is from an after tax. One way to avoid this is what I really like to do is I call it a bucket approach. I really like to bucket together like assets. So you'll put together the primary home should be its own bucket. The brokerage account and liquidity assets should be another bucket. And then retirement assets should be another bucket. And the goal really is to first look at what would this look like if we split the retirement assets, if we split their brokerage assets, if the primary home, the equity out of the primary home, if someone wants to buy them out, that should be some type of cash payout. And then if it's not, you start to look at if I'm going to be taking retirement assets for equity that I have in the primary home, then my assets should be slightly discounted for the taxes that I'm going to have to pay. I'll take the next slide, please. So at the end of the day, you really want to, and I'll also talk to the primary home. That is something that is unique in that you get a $250,000 marital or $250 capital gain exclusion. So that's why I like to consider the primary home in its own bucket, because that means that for of the capital gain that you're going to have to pay taxes on, that you only have to pay. So if you, let's say you have a $300,000 capital gain, you get to exclude 250,000 of that capital gain. So you have a much more attractive asset. So really what you need to do is you should really look at the after tax value of each of the assets when you're looking at it. And again, it's not a number that you need to, but you should know general ballpark on what something is worth and what any embedded tax consequences are. And the next slide, please.
Yeah, I just want to interject real quick, Barb. If you guys have questions, to use the Q&A at the bottom of the page to ask any questions. Thank you.
And then I did want to just talk to, there was a couple questions that we got in advance. One was about when you file taxes. You have to, whatever your status is as of 12/31, that's your status for filing a tax return. So I think in this case, the person that had asked the question might have gotten divorced on December 29th. If you're divorced on December 29th, then you'll have to file single. If you're separated but still married on December 31st, then you have then the option to file either married filing jointly or married filing separately. But it's all determined based on what your status is as of 12/31. And then I'm just quickly looking to see if we have any other taxes. So I think the main takeaway is really when you look at your settlement agreement, it's really important, even if just for a couple hours, grab a CDFA or a CPA and run your settlement agreement by somebody that can just quickly review and have a really good understanding of what you're getting. So when I work in my CDFA, I work with a lot of clients that are going through divorce, that are thinking about divorce. And then post-divorce, we believe in it's great to have a team, and a great team member that I have is Robin, and she's going to talk to you a little bit about post-divorce.
Hi, everyone. So nice to be with you tonight. Thank you, Barb. Barb and I work together a lot and overlap on a lot of these decisions and helping clients. I generally work on the post-divorce side, which is helping people figure out what's next in life from a financial perspective. So they are rebuilding their financial picture. They are figuring out what has changed. And one of those big things that have changed is their taxes and all of how they own their accounts. So there's going to be a little bit of overlap, and we're going to talk about that as we go here. So the first thing that Barb mentioned was, yes, you are going from generally. Now, these are all, let me just give a little bit of caveat. These are general statements around taxes. I work always in collaboration with the CPA, doing tax projections and considering clients' unique situations, which may be different from the general tax rules. So I just want to say that. And then state taxes are a whole nother thing that you have to consider. Thankfully, in New Hampshire, not as much as some other states. But so first, yes, you have to shift from married filing joint when you file taxes on your own, maybe for the first time or for the first time in many years. Or you have the option of head of household, potentially if you have dependents. So working with, if you have dependents, working with your attorney and someone like Barb to make sure that those things are included in your divorce decree are a really great planning strategy, because they can be valuable to you and they may not be valuable to your spouse. You'll want to update your tax withholdings, and we're going to talk some more about that as we get to the next slide in a second. But you don't want to have a big tax liability. So you're on your own now, have all of these different layers of income, and you're trying to figure out what your taxes are. Part of the tax planning process in my world is doing a tax projection, understanding what your income is so that you can make sure that you're taking the right withholdings out, either on your wages, on your Social Security payments, on retirement plan distributions. We'll talk a little bit more about that in a minute, but that's a big change for people that they can get blindsided by. And then start preparing. So here we are in January. I already got my first 1099 from one of the investment companies. So you want to start keeping those in a folder, and anything that you've done in 2025, if you're filing on your own in 2025, so you're already divorced. For people that are just getting divorced in 2026, it wouldn't be, you'd most likely be filing married, filing joint, just to be clear about that. And then you just generally want to keep your tax documents in their own folder so that you have a quick place to go when tax time rolls around. So if you want to go to the next slide. So just like all assets are not the same, in Barb's world and in the pre-divorce planning, it's somewhat theoretical, right? You're looking at a lot of numbers, but when you get to the post-divorce side of things are real, and you're trying to make a plan for today and the next 20, 30, 40 years. So understanding all of the different buckets that you're receiving from a cash flow perspective, asset perspective, income perspective, and understanding how each of those buckets are taxed are a big part of creating a paycheck for yourself. So in general, and again, I put generally on this stuff because it really depends on your situation. But as of 12/31/2018, alimony and child support, well, alimony is not taxable. Child support has never been taxable. So every dollar that you receive from your ex, you get to keep. No taxes due on that. If you have wages or you're getting a benefit from a pension account or you have your own self-employment income, those buckets, when you get a dollar, a piece goes to the federal government and potentially the state government. So those are taxed at ordinary income rates. Barb talked about retirement plans. Generally, you can have some big buckets there, but those aren't taxed until they're actually taken out. So strategies around multi-year tax planning are important so that you can decide when the best time to start doing that is to get the lowest rate possible. If you're single or head of household and you don't have much income, there may be, if you're over age 59 and a half, may be very good reason to take some of the money from a retirement plan. Working with an advisor or CPA or in collaboration with both of those is a really important step. to make sure that you're lowering your tax bill as much as possible. Then we have Roth IRAs, which are generally tax-free. So those are the retirement accounts that you contribute after-tax dollars, and then they grow tax-free. And when you take them out, if you've over age 59 and a half and you've held them for 5 years, then you can take them out tax-free. And so in a divorce situation, if you and your husband started a Roth IRA 10 years ago and you're age 60, you could take dollars out of that Roth IRA as long as the contributions were held in there for 5 years. So that would come out tax-free, potentially. Social Security, that really is based how much of that is taxable, 50 or 85%, or potentially zero, depending on your other income sources. Understanding how that layers with other income sources is an important part of the tax planning. Rental real estate, you're only taxed on the net income, which is your gross rental income less all the deductions. So working with your advisor and CPA to make sure you get as much deductions as possible. What shows up on your tax return is a net amount. It's an important part. It takes a little more time, and there's a whole strategy around how to keep track of that stuff. But if you have a rental real estate property, maximizing deductions to make sure you can get the most amount of paycheck that you can. And then investment and annuities, tax treatment varies on these. As Barb mentioned earlier, we have a lot of divorced women and men who come in with very low cost basis securities because that's what was given to them in the divorce. And so they have to pay capital gains on those dollars when they sell them to fund lifestyle and other things. And knowing what that is will help you do a multi-year strategy again around getting the dollars out at the lowest cost possible. Some of it might not matter and will have very little tax due, very little capital gain, but also some could have big cap gains. So understanding that and working with your financial advisor to chart that out for you is a big help in making good decisions around your taxes. And then, yes, I forget. We're moving on to post-divorce. So this slide is generally about if you get in your settlement large amounts of retirement plan money, so IRAs, 401ks, and really don't have a lot of taxable assets. So I have 2 clients right now that I'm working with. One is so these are 2 strategies listed here that can help you if you're under age 59 and a half, which there's a 10% penalty on retirement money if you take them out before you're 59 and a half. So IRAs, 401ks, all of that. If you took it out at age 55, the IRS would hit you with a penalty in addition to the income taxes. Again, trying to reduce taxes and get the net paycheck as high as possible for clients. You're allowed to, in 2 situations, avoid the 10% penalty. The first is if in the divorce settlement, you were to get your ex-spouse's portion of the 401k plan, you would need to do a quadro, which is a qualified domestic relations order. And in the quadro, it would need to state that you would like to take a one-time distribution from that 401k plan to, you don't have to say why, but essentially to fund whatever it is that you want to fund. You would pay taxes on that asset in that year, but you would not have to pay the 10% penalty. So that can be a nice way to get some emergency funds or provide for a goal that you might have, college funding, anything that would help you raise some liquidity if you don't have one. Again, working with your quadro attorney, a financial advisor, tax person, all those things are important to make that happen. And then a substantially equal periodic payment from an IRA bucket. So you would need to carve out an IRA to do this, and you could come up with a monthly income stream from that account. But you must continue that income stream for 5 years or until you're age 59 and a half with no changes. So there are some restrictions around these things. And I guess given that most of you are pre-divorce, I just want you to know that they're out there and available to you and that you should work with someone. If you have that situation, there are some ways to create some liquidity. And those are 2 of the ways. And then a few just other random post strategies for minimizing your tax liability is to contribute if you're working or you have self-employment income, you are able to reduce taxable income by contributing to your retirement plans, whether it be a 401k, a 403b, a SEP if you're self-employed, or just a regular traditional IRA. I highly encourage you to do that, to save for retirement. Especially if you're younger, you'll want to continue to do that for your own financial future. There are a lot of tax credits and deductions, child tax credits, education tax credits that you should look at to see if those apply to you, which could also help cash flow and reduce taxes for you. You do want to make sure you keep all tax-related documents in case of an audit or any other tax-related issues. So again, whether it be an online folder that you have that's secure or a folder in your home, having that stuff in one place will really help you as you're working with your advisor team to make these decisions. And I've talked, I think, a lot about the last bullet, which is these things are complicated and there are a lot of decision points. Finding your team and making sure that they collaborate together on your behalf will benefit you long-term and help you gain the financial security that you need. Thank you. So we're moving it on over to Renee. Renee's going to talk about real estate and taxes. Thank you.
Thanks, Robin. And Laura, if you want to hop on for a moment as well, so you can introduce yourself. So I'm Renee Coleman. I'm a residential mortgage lender and a certified divorce lending professional. So I just wanted to talk briefly about real estate in general and what happens as far as capital gains. So the first thing that we have to do is value your property, right? And once we know the value of your property, that helps us determine if there's going to be a gain. And so I wanted to quickly introduce Laura, and she can tell you a little bit more about valuing the house and what that entails.
Thank you so much, Renee. I appreciate that. So as everyone has mentioned just throughout the presentation, is just the real estate and just knowing the different buckets, which, as everyone has mentioned, real estate being one of those buckets, right? It's very common that a home, it is one of the biggest assets and one of the biggest negotiation items when it comes to a divorce. Definitely just pulling in a professional real estate broker at some point. The earlier on that we're brought in is the better, just so we can help. Before you talk to Barb and Robin, Renee, a lot of the time they're all going to be looking at me to say, hey, this is all great. Where's the value and what do the numbers look like, so we know what to negotiate at the end of the day for your best interest. The earlier that we can offer free market analysis at zero cost and offer just multiple solutions that could be just tee you up in the best case scenario. Again, this is all about the taxing, the legal aspect of it. And when it comes down to it, you just need to know what the numbers and the value are of your assets. Just very much recommend that you just make sure you have someone in your, so to say, there, and really make sure that you have a professional that really knows your local market to just, depending on where you are in the process, if you're earlier on, which it sounds like many people are, and what's the best time to position yourself if coming to have to actually sell the property, because that's where you're sitting on the monies of that you can make sure that you're making the right decisions. Thank you, Renee. Again, this is all very just a wealth of knowledge that I wish all of my clients had this webinar to listen to ahead of time. So I hope everybody takes all this information and really digests it all, because this is great information that I truly see a lot of my clients not have the right information ahead of time and make some really wrong and unfortunate decisions when it comes time to filing their taxes, and didn't realize that the consequences that are on hand. And are at that point, unfortunately, forking over a lot of money to the government and or their spouse. Thank you, Renee. I'll have you take it over from there.
Thanks, Laura. Yeah, and getting a value on the house, that's step one, regardless, whichever way you're going to go with the house, right? If you're going to keep the house, if you're going to be bought out, or you're going to you're buying your spouse out, or if you're going to sell the house, regardless of which path you might take, we have to have the value. And one of the things Barb was talking about was, and Robin mentioned too, not all assets are equal. And there's tax consequences to whatever decisions we're making. And on the real estate side of things, the decision, if you're perhaps the spouse wanting to keep the house, that's where I see this often as a mortgage lender. People will come to me and say, we're getting divorced. I would like to keep the house. One of the things that I will always talk to them about is the capital gains that they might have to be considerate of. So once we have a value to the house, that's capital gains. It doesn't have anything to do with if you have mortgages on the house. It's, in simple terms, the purchase price of the home and the value of the home if you were going to sell it today. And any of that gain in there is what you have to pay taxes on, and it's called capital gains tax. So if you're the spouse wanting to keep the house, and let's just say, for example purposes, you've got $300,000 in gain, right? Maybe we bought it for $200 and it's worth $500 today. There's a $300,000 gain in there. And the way capital gains tax works, this is just for primary residence. This is your home that you're living in. And the rules are, there's an exemption that, that $300,000 gain that you have, if you were selling the house as a married couple, there's a $500,000 exemption. As long as the home was your home 2 out of the last 5 years is the rule on that. So as a married couple, if you were selling that house, there's a $500,000 exemption. So there's no gain tax that you would have to pay. But if you are a single person selling that house, right? If you're the spouse wanting to keep the house and maybe you're going to sell it down the road and there's a $300,000 gain, you have a $250,000 exemption as a single person. So now you have a $50,000 gain that has a tax consequence, and it's usually 20%, right? So if we've got $50,000 in gain, you're going to be responsible for 20% taxes on that. So that's really what I wanted to make everybody aware of, especially on the real estate side of things as far as taxes go. Again, rental properties don't have that exclusion. So you can talk to your accountant on that. And we heard Barb, she loves taxes. I'm not sure I've heard many people say that before. So that was what I wanted to talk about tonight. And I think we have Michelle up next.
We do. Thank you, everybody. Welcome. I am Michelle Papandrea. I am a certified divorce coach. So tonight we've learned a whole lot about taxes, finances, capital gains. Can all be a little confusing, overwhelming. I'm only a coach, so I won't say only, but I can't explain everything that the ladies just explained, but I can help you get in touch with the right resources as we could potentially work together. As a coach, we work through the emotional pieces, the process of divorce. I believe noted that a lot of people are either at the beginning of their divorce or just asked for a divorce or are contemplating divorce. So when you work with a coach, we talk about we talk about setting goals. We talk about how do you communicate with your spouse? How do you tell your spouse you want a divorce? How do you talk to the kids? How do you co-parent? We can work on a budget, but we really walk side by side through the whole process, pre-divorce, during divorce, post-divorce. And if any of the conversations that we were just talking about taxes get overwhelming, I'm your go-to person. Come to me. We can chat through it, help get you further clarification if needed. Write down all your questions, and very lastly, save you money. So working with me, I help you get organized. I can, like I said, help you with a budget, help you interview with interview questions for lawyers, mediators, writing down all your questions post once you've hired somebody so that you're fully prepared. We talk about generally what certain things mean, what to expect when you show up to a mediator, a lawyer, court, etc. And so we do talk a little bit about emotions. I have a few listed here. Divorce is a big grieving process. It's a big loss. And most people outside of those of us who've been divorced don't really understand the grieving process and what you might feel. As someone who has been divorced and is a coach, I understand that grieving process. And if you're asking for the divorce, you've been contemplating this for a while, your other partner, they're just learning this for the first time. Maybe you've been talking and thinking about it for months or even years. So whatever emotions you are feeling, allow yourself time to sit with them, process them. You don't have to rush. Divorce can be an emotional roller coaster with anger and confusion, fear, anxiety, and many more. So I think at the end, we're going to put our contact information in here. I certainly will. And I think that Adrian is up next.
Good evening, everyone. My name is Adrienne Boulogne, and I'm new to Vesta. I'm new as a provider joining the New Hampshire Hub. I'm happy to meet everyone, and I just wanted to introduce myself so that you were familiarized with the services I provide. I'm a psychotherapist, a behavioral health consultant, and a transformational coach. I wanted to get involved with this community because I also have lived experience with divorce and high conflict co-parenting, which has inspired a lot of the interventions I pulled together for my clients. I really love doing this work. And I have a virtual practice in New Hampshire, and it's accessible really from anywhere. It's called Better Half. And I specialize in relational intelligence. So, emotional intelligence is a popular word right now, and relational intelligence is really the inner and external workings of how we connect with others, and most importantly, how we connect with ourselves and how that impacts our conflicts and our ability to transcend into positive and healthy relationships. So I work with couples and I work with singles that are maybe dating or working to recover from relational trauma. And I also work with co-parents on how best to navigate effective communication and working towards aligned goals. Let's see, as something that can give you a flavor of some of the work that I take people through is I have an upcoming event next month. So this is a divorce recovery retreat. And it's a pretty unique event that blends EMDR, which you might have heard of, which treats trauma. And we're doing a intensive that is curated to respond to relational trauma and provide the coaching aspects. So people really go from a survival state of where they are in their divorce journey and just in a few days actually come out on the other side with more of a revival and feeling connected to what the next step's going to be and feeling that they have a refreshed perspective. So I'll be sure to include with my information the link to find out more information about the retreat and speak to me directly about it so you can get the details, and also include the flyer so you can pass it on to other people you might know that might benefit. Thank you. Thank you so much.
Okay.
Thanks, Andy.
You're it. I don't
I
think
was going to say thank you. Have we not seen Kate yet?
I don't think so. Lori? We'll have Lori take over to talk about the legal pieces, and hopefully your counterpart will join you. Otherwise, you're bringing us home. No pressure, Lori. Thank you.
You're welcome. Okay, my name is Lori Barron. I'm a licensed attorney in Massachusetts, New Hampshire, and Connecticut. We are talking about New Hampshire today, so that's what I'm going to be focusing on. So what I do in my practice, I don't do divorce litigation. Kate does the divorce litigation. Kate does the divorce litigation part. So I'm going to talk a little bit about what that is, but I'm going to focus mainly on the mediation and the collaborative law, which is what I do. Essentially, there's three ways that people can, actually 4 ways people can approach divorce. One is litigation, which I'm sure you all know about. The other one is doing it pro se, which means doing it by yourself, which is not recommended. As you can tell, there's a lot of nuances and financial issues and a lot of things that really need professionals to help walk you through it, and in particular, an attorney to help guide you through the legal process. And the other two are mediation and collaborative divorce. So litigation is what you think it is. You file for divorce, the other party gets served, there's discovery, it's under the court's watch, everything is done via hearings, and it's a very clinical way to do it. It's very regimented. You're on the court schedule. There's fighting back and forth, usually through motions and things like that. Sometimes really contested divorces or divorces where each party just is not willing to sit down and kind of mediate, talk it through, work it through outside of court. Those litigation is the right course for them. And again, I'm not going to speak too much about the litigation because that's Kate's portion, but in terms of how mediation fits into the litigation part, the court actually encourages mediation even during litigation. So it's not mutually exclusive. You can start the litigation process and then move to mediation and then wrap it up with the mediation process, bringing it back to court for a final approval. Oftentimes, cases don't go to trial. Only about 4% go to trial. It's a very expensive process, only to end up not having a trial and going through the emotional stress of having to go before a judge every 3 months, perhaps. While it is an option, there are alternative ways to come to the same resolve at the end, which is a separation agreement and which is an agreement presented to the judge for approval. So now I'm going to talk about mediation, which is what I do, and collaborative law, which is what I do also. So mediation is a voluntary process where both parties agree to sit down and work out the issues at a table with a neutral third-party mediator. Not all mediators are attorneys. However, a lot are. I am. And so what the mediator does is facilitates a conversation. So in facilitating the conversation, they're not representing either party. And they don't give legal advice. But what they do is help facilitate the conversation, inform the parties of the court's rules, because that's not advice, though that's just information that's readily available out there, and then help individuals work through the issues to come to some sort of agreement on a particular issue that falls under the umbrella of the court rules, and that is likely to be approved by the judge. When you're in mediation, you take the reins on the conversation. The agreement in the end is what both of you agree on. Now, mediation doesn't necessarily have to be amicable the whole way through. It does have to be civil, but there can be times where you don't agree on something. And that's the purpose of mediation, is to sit down and deal with that issue and figure out why there isn't an agreement. What are the issues underlying that non-agreement? And work through that. And that's where the divorce coach can come in handy, because they're outside of the mediation room. They're outside of the mediation process. They're separate. If there's a particular point that there's no agreement on, you can go back to your divorce coach and try to figure out why. What is it from an emotional perspective or things like that? You can contact your CDFA and get more informed in terms of the financial state and the realities of the financial situation to help you be better informed during the mediation process. So the mediation process is an alternative to being in court, but the issues that are dealt with are the same as in court, because there are certain things that need to be addressed: child support, alimony, the equitable distribution of the assets. So while it's not being while it's not being addressed in court, it is being addressed, because ultimately, whether you go to litigation or whether you go through mediation, it has to go before a judge. It has to be presented to a judge, and a judge has to approve it in order for the divorce to be finalized. So it's a great way to empower yourselves instead of having the court determine what's right for your situation. And it's great to have all of these professionals on the outside helping you come into the mediation with very informed. It helps facilitate the process instead of sitting at the table trying to figure out what taxes will you be left with? What taxes will I be left with? So you come in not having to deal with that at the table, and you can just address the issues of figuring out what to put on paper in terms of a final agreement. It's a lot cheaper than litigation. And again, your rights are protected because nothing that you put in that agreement will pass muster with a judge if there seems to be a power imbalance or somebody is getting way more than the other person is getting. However, if that's the agreement that people come up with, the judge will look further into it and try to get an understanding of why that is. And depending on what the rationale is, the judge may approve it, or the judge may push it back and say, this needs to be a little bit more equitable. And then you come back to mediation, you work it out. But again, this is all done outside of court. So in terms of an attorney, it's not required to have an attorney for mediation. It is highly encouraged to have legal guidance on the outside the mediation room. Before you sign anything, before you agree to anything, you should speak to an attorney. Usually they're paid by hourly to do that. There's no retainer for that. And so you have your legal guidance and the information with you before you come and sit down at that table. And then once the agreement is completed, then it's highly recommended that you bring it back to your attorney to have them look it over to make sure everything is good and it is in your best interest. Now, I want to qualify that in your best interest, because if you're going to have do mediation and have an attorney look at it, you want an attorney that is mediation friendly, because something being in your best interest or an agreement being in your best interest, or an agreement having you get as much as you can get, are two different things. The whole purpose of mediation is a negotiation. It's a compromise. And if you go to an attorney that is just looking to get everything that you could possibly be entitled to without taking into consideration the give and take that's required during a negotiation, and without taking into consideration that you are comfortable with this agreement, knowing that you're giving up something to get something, then there might be an issue with that. As long as the key takeaway with mediation is, as long as you're both comfortable with it, and as long as it falls under the rules and it's fair and equitable, that should be approved by the judge. It's a very empowering modality to work through an agreement, get it resolved, taking into all the factors, all the emotions, all the peace that both of you are seeking. So just trying to see if there's anything else that I have regarding mediation. I believe I said it was a lot cheaper and it's a lot less stressful, and it provides for more peace. Now, in terms of collaborative law, I like to call a hybrid of litigation and mediation, because it is an outside of court modality. So there's no court, there's no litigation. However, you are represented by attorneys through the process. So each person has their own attorney. There's no third party neutral in terms of legal representation. So you're each represented by an attorney, but there is a process where you actually go before what could be considered a third party neutral to help facilitate the conversation. And you also make use of all the outside professionals, CDFA, divorce coach, parenting coach if you have children. But it's more structured in terms of the team environment that you're working in. So there are meetings where you and your attorney sit at the table with your partner and their attorney, and you work through the issues. But even with collaborative law, even though it's more legal in its essence, the parties are the ones that are doing the speaking during the negotiations. So it's instead of, as opposed to in court where your attorney is doing all of the talking. So it brings it to a place where the parties feel heard, just like in mediation. Any issues that come up, emotional issues, any other issues that come up are dealt with. The pain and grieving of divorce is acknowledged and part of the conversation, just like in mediation. So it's appropriate for some types of divorces, some relationships or some issues that just people need that extra support of an attorney. The one thing about the collaborative process is that if it has to be voluntary, but if people decide not to continue with collaborative and go into litigation, their collaborative attorneys cannot represent them in the litigation, in actual litigation. So they would have to find a new attorney. And just getting back to mediation, when you do mediation, if it's not working, you can go to litigation. Just like if you're in litigation, you can go to mediation. Same is true the other way. If you're in mediation and it's not working out, you always have a remedy in court. There's a lot of mediation, collaboration, the collaborative law. They're good processes in and of themselves, but they do work. They can be part of the process in determining what is the best course of action. You can start with one, move to the other, go back to what you started with. So it provides a broader sense of your control, of your ability to control the process. And I think that is all I have. I don't know if Kate's here yet, but if she's not, then I think I'm done with my presentation today.
I just jumped on, and I'll just briefly introduce myself, but I think maybe add one more point. Hi, everyone. I'm Kate Blake. I'm a family law attorney. I'm licensed in Massachusetts and New Hampshire. I apologize for being late. I had a trial today, so didn't get out of court until after 4 and then had to get home to get to my computer. My practice is both out-of-court resolutions and not acting as a mediator like Lori does, but helping people through the mediation process. I also am collaboratively trained, so I do collaborative divorce. I also do direct attorney negotiations, so all those different out-court resolutions that Lori mentioned. And then a component of my practice is litigation-based. And I think really the only thing I kind of want to highlight is that a process choice isn't like first of all, it's not a one-size-fits-all. And also, you may jump back and forth between a couple different types of processes. In New Hampshire, if somebody files for divorce, the courts really want to encourage and do encourage people to attend mediation. So you may have an open litigation, but you may end up in mediation. I've also had cases that have started as mediation, then we switch to collaborative, then we switch back to mediation. So it is and can be a fluid situation depending upon the circumstances of your case. And then, Laura, you want me to handle some of this, the legal components?
Yeah.
Okay. So at a very high level, when we talk about financial support, there's two types of support. One is alimony, which is support for a spouse. And in New Hampshire, we have a statute that says alimony is going to be 23% of the difference in the party's gross incomes. The statute also talks that the maximum duration would be half of the length of the marriage. And if there is an alimony component, then there's a document called the Uniform Alimony Order that needs to be completed and filed with the court. Separately, we have support for children, which is called child support. And that is based on a formula that's revisited by the state every few years and revised. And if there is going to be a child support component, then that's a document called a Uniform Support Order that needs to be filed with the court. If there is alimony and child support, that becomes a little bit more nuanced, and there's some interplay between the two of those. So that is something that you just want to be mindful of. And then child support is for basic child-related expenses, food, shelter, clothing, that type of thing. As we know, children have many other expenses. So things like uninsured medical expenses, we need to identify how those are going to be shared between parents. In New Hampshire, child support will end when the child emancipates, which is generally 18 or graduation from high school. There is no legal obligation to support children once they have graduated from high school. You and your spouse can obligate yourself to contribute towards college, but that's not something that a judge can order either one of you to contribute to. And then, as Lori had mentioned, division of assets, New Hampshire is an equitable distribution state. Equitable does not mean equal, but generally, the longer marriage goes on, the more likely assets are going to be divided approximately equally. And what's also important to know is that all assets, regardless of how they were acquired, when they were acquired, or whose name they are in, is a marital asset. It's just a question of how it's going to be divided between the parties. I don't know if you have anything that you want to add to that component, Lori.
I don't think so. I think I covered it pretty well.
Okay. And then in terms of equitable distribution of the marital estate, it's a matter of identifying what the different assets are. New Hampshire has a document called a financial affidavit where you have to list your income, your assets, your liabilities, and your expenses. It's a very important document. If you are contemplating divorce or really early in the process, I highly recommend that you get a blank form to start working on. I find that form can be very daunting to people to fill out. And if you are one of those people who have concerns about how to complete that, I highly recommend working with a CDFA like Barb because she knows that form inside and out. It can save you a lot of legal fees from having me or my staff work on that when Barb can do that in a much more streamlined thing. So want to make sure you're identifying real estate. Real estate, the value is going to be the fair market value minus the mortgage. Your tangible personal properties like your things, your cars, any extra personal property that you have. Intangible are things like bank accounts, retirement accounts, if you have investment accounts. If anybody has a business, that is considered a marital asset. It then becomes a question of, is there a value to the business or is it really a stream of income that we're looking at? And then that goes to support. And then we also have to take into consideration debt that may be existing, credit card debts, student loans, car loans, that type of thing. We need to identify what those are and how they are going to be divided between the parties. So I think that's the end of our presentation. If anybody wants to jump back in, something that might have popped into their brain while we were going through all of this, any kind of parting words that anybody has.
Thank you, Kate. Give everybody a second to jump back in. So a couple of things in conclusion here. And I think we've answered all of the questions that were in the Q&A. If anybody has any last minute questions that they would answered, please feel free to put it in the Q&A. Otherwise, I think we're going to wrap it up for tonight. I don't see anything else in the Q&A. So thank you everybody for attending, and thank you all to the panelists for giving us all of your wealth of information. I know this topic, I know Barb's not on the call anymore. She's so funny. She loves taxes. Not paying them, however. She loves figuring out how not to pay them. Thanks again for joining us tonight, and please feel free to check out Vesta's website to learn about our upcoming events at this New Hampshire hub, but some of the other hubs across the country for some great information. Thanks, everybody.
Thank you. And Renee, that concierge is